Hello, everyone, and welcome to In Solidarity, Union Support for Pregnant and Breastfeeding Workers. We're pleased you've joined us today. I'm Carol Joyner, Director of the Labor Project for Working Families. We work in partnership with Family Values at Work, the network of 24 state coalitions fighting for good work and family policies. Next slide. If you have any questions throughout the webinar, make sure that you type them into the box on your GoToWebinar screen, or you can email them to questions@worklifelaw.org. We'll answer them all at the end of the webinar. Next. So this webinar is based on the Shop Steward's Guide to Counseling and Representing Pregnant Workers, which was created by the Pregnancy Accommodation Working Group, which is convened by the Center for Work-Life Law at UC Hastings College of Law, and it includes A Better Balance, SEIU, the AFL-CIO, and the Labor Project for Working Families. We also have a number of unions and shop stewards to thank for reviewing the guide and providing important suggestions along the way. As you know, pregnancy discrimination and accommodation is critical, especially in these times with workplace rules, policies, and even union contracts being challenged. Pregnant women are especially vulnerable to getting pushed out of the workplace, harassed on the job, and denied their rights. The toolkit provides unions and shop stewards the legal and contractual means to fight back. It covers the key federal and state laws, union contract provisions, and other protections for breastfeeding and leave. It also includes great tips for stewards with steps for addressing many of the problems that arise and a clear plan for handling grievances. The goal today is to highlight these aspects of the guide. Our presenters to do so are Tiffany Baroyd, UFCW organizer and one of the founders of Our Walmart's Respect the Bump. She'll lead us off with her account of how she was denied pregnancy accommodations and decided to fight back, ultimately organizing others to change the Walmart policy. We'll also hear from Yona Rosen, Associate General Counsel of the AFL-CIO, who will discuss pregnancy discrimination, practical tips for protecting pregnant workers, and getting accommodations. And finally, Liz Morris, Deputy Director for the Center for Work-Life Law, will review both federal and state law and protections under collective bargaining agreements. We'll then wrap up with a call to action, your questions, and your thoughts about the webinar. Next, please. We'll start now with Tiffany. Thank you.
Hi, my name is Tiffany Baroyd, and I'm an organizer with United Food and Commercial Workers International Union, where we represent 1.3 million hardworking women and men across the country. Before I started my journey as an organizer, I worked for Walmart for 4.5 years. In 2012, I found out that I was pregnant with a high-risk pregnancy. For the first 2 trimesters, I was able to keep doing my job as usual, which included heavy lifting of boxes and pushing carts. The start of my 3rd trimester, my doctor said I would need simple accommodations to continue to work and protect my pregnancy. The accommodation included frequent water break, sit as needed, and avoid heavy lifting. Walmart denied my doctor's request. Instead, they suggested I take an unpaid leave. Because I could not afford to take an unpaid leave, I ignored my doctor's orders and continued to work. 1 week after that, I was beginning to experience more complications. My doctor said without the proper accommodations, I would not be able to continue to work. After Walmart denied my doctor's request again, I was forced to take the unpaid leave to secure a healthy pregnancy. At the end of my 3rd trimester, I was thrilled to have given birth to a healthy baby girl. I then returned to work where I learned about UFCW's Making Change at Walmart's campaign. Next slide. I began to share my experience as a Walmart worker being pregnant on the job, and I became a founder of another UFCW-led campaign called Respect the Bump, where women across the country started to take a stand and share their experience about being pregnant at Walmart. Many, many allies, labor unions, and women organizations joined us in the fight for justice. No one should be forced to choose between their unborn child or continuing to provide. With a great amount of solidarity, we applied pressure to Walmart by presenting a resolution to their shareholders. In result, Walmart upgraded their pregnancy policy in 2013 to allow accommodation for women with high-risk pregnancy. Even though the pregnancy is change is even though the pregnancy policy change is a step in the right direction, many women are not being accommodated still. As an organizer assigned to the Making Change at Walmart campaign, I'm continuing to seek justice. Thank you.
Thank you, Tiffany. And now we'll go to Yona.
Thank you, Carol. This is Yona Rosen with the AFL-CIO. The Pregnancy Discrimination Act of 1978 and many state laws prohibit discrimination based on pregnancy, childbirth, or related medical conditions as a kind of discrimination based on sex. Next slide, please. What this means is that an employee who is pregnant or who has experienced childbirth can't be fired, demoted, denied a position or a promotion, or made to suffer any other negative consequences due to pregnancy or childbirth. The bottom line is that the pregnant worker should not be treated differently from any other non-pregnant workers who are similar in their ability or inability to do their job. And employers should not make assumptions about a worker who is pregnant, like that she won't come back to work or will be less interested in or less committed to her job after she returns from childbirth. Employers should not hold pregnant women to a higher standard of performance than other workers. For example, penalize pregnant women for being tardy if other workers are tardy without penalty. Next slide, please. So not only does a pregnant worker have this protection under federal and some state laws, but union workers covered by a collective bargaining agreement may have even more protection under their contract. This is because most collective bargaining agreements include an anti-discrimination provision or a provision that the parties will be bound by all state and federal laws, or even just your normal just cause provision that provides for equal treatment among bargaining unit employees. So let's consider an example of a claim for pregnancy discrimination under a union contract. This example comes from an actual case of a woman whose union filed a grievance on her behalf when she was denied the opportunity to request a transfer because she was pregnant. The Communication Workers of America filed a grievance on behalf of member Catherine Bishop when Mountain States Telephone Company disqualified Catherine Bishop from requesting a new assignment because she was pregnant. The grievant was eligible under the collective bargaining agreement to apply for transfer from the classification of telephone operator to the classification of service representative. Because her supervisor suspected she was pregnant, the company refused to allow the grievant to apply, claiming she was disqualified because she would have to take time off to have her baby while she was still undergoing training for the new position. Now, of course, any employee who transferred might have to take time off during training due to an illness or an injury. The company actually admitted that Catherine if she had not been pregnant, she would have been awarded the requested transfer. After an arbitration hearing, the arbitrator ruled that the company's actions violated the contract provision prohibiting sex discrimination, among other kinds of discrimination, and awarded the grievant back pay and the opportunity to transfer to the new position. Now, I want to briefly talk about some practical suggestions when those of you who are stewards are trying to represent one of your members who is pregnant. A lot of workers don't really know what their rights are when they're pregnant or if they need to take leave for childbirth. You can use the Shop Stewards Guide, which will be sent to you after this webinar, to understand what rights your members have, both under the law and under your contract. You can help a woman understand what she can and can't ask for, and you can go with her to talk to the supervisor or to HR to make sure she has what she needs. You can do research and get information to help her show how other employees are being treated, and if there are differences in how they're being treated as compared to the pregnant worker. Taking a positive approach and helping the pregnant worker make a plan with management or HR can be beneficial to everyone, the pregnant worker, her co-workers, and the company. Now I'm going to turn it over to Liz Morris to talk about possible accommodations.
Thank you, Yona. So when we say accommodation for pregnancy, what are we talking about? We're talking about adjustments or modifications in how or where or when the job is done that will allow the pregnant worker to stay on the job and continue earning an income while still maintaining a healthy pregnancy. In other words, there are changes to the job that allow the pregnant employee to keep working. So examples include receiving a stool for sitting, carrying a water bottle, taking additional breaks for snacks or resting, working a modified schedule, taking time off for prenatal care appointments, receiving assistance with heavy lifting, or receiving light duty assignments, or any other creative change that you can come up with that will allow the employee to continue working. So think back to what Tiffany told us about her experience working at Walmart. She had a high-risk pregnancy, and her doctor recommended that she do work that allow her to stay off of her feet and take breaks for resting. Walmart, as Tiffany told us, denied this request, and Tiffany had to work under unhealthy conditions until ultimately she had to go out on unpaid leave, even though there were accommodations that would have allowed Tiffany to continue working. So the question is, what legal and contractual obligations do companies like Walmart have to provide accommodations? It turns out that although not every pregnant woman who needs an accommodation will be entitled to receive one, in many cases there are either laws or collective bargaining agreement provisions that will provide a right to a pregnant woman who needs an accommodation. So I want to share with you 3 sources of law that may provide a right to an accommodation in cases like Tiffany's. The first is the Pregnancy Discrimination Act, which applies to private and public employers with 15 or more employees and provides a right to accommodation for pregnant workers when other non-pregnant workers with similar abilities or inabilities are receiving accommodations. And this is the law that Yona mentioned a few minutes ago that requires pregnant women be treated at least as well as other non-pregnant employees. So think about, for example, a shop where there's a light duty policy and it applies to people who are injured on the job, it applies to people who have temporary medical conditions, but it doesn't apply to pregnant women who need temporary accommodations. That would violate the Pregnancy Discrimination Act because the employer is treating pregnant workers worse than these other categories of employees. The second law to be aware of is the Americans with Disabilities Act. That's a law I'm sure you've probably all heard of. It applies to private and public employers with 15 or more employees, and it requires that employers accommodate people who have disabilities so long as an accommodation can be provided without imposing an undue hardship on the employer or an undue difficulty or expense. Now, pregnancy all on its own is not a disability, but many conditions that are caused or exacerbated by pregnancy are considered disabilities under the ADA and therefore have to be accommodated. So workers who need accommodations because of significant morning sickness or gestational diabetes or serious back pain, pregnancy-induced carpal tunnel syndrome, those folks may be entitled to accommodations under the ADA. Finally, the laws of many states require accommodation of pregnant women, even in situations where other employees aren't receiving accommodations, even when there's no disability. So I've listed here the states that have some form of additional laws protecting pregnant women, and what they provide differ from state to state. But the states are Alaska, California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Iowa, Louisiana, Maryland, Minnesota, Nebraska, New Jersey, New York, North Dakota, Rhode Island, Texas, Utah, and West Virginia. So with that background, I want to tell you about the woman, pardon me. So your collective bargaining agreement may also have provisions that, your collective bargaining agreement may also have provisions, just like with pregnancy discrimination, in the context of pregnancy accommodation, that provide protections. So there are provisions that may already be in your contract. For example, the just cause provision, the anti-discrimination provision, the requirement that employer complies with all federal, state, and local laws. Those provisions may provide accommodations for pregnant women. Next slide. So the shop steward's guide also includes important information for how pregnant women should ask for accommodations. There are no magic words that must be used, but there are certainly things that pregnant women can do and say that will significantly increase the likelihood that they'll receive the accommodation they need, and they'll be able to continue working and earning an income. So we have some of those things listed here. Pregnant women should come prepared with a plan about how the accommodation they're proposing will work. And they should be as specific as possible about what their work restrictions are, and make sure to emphasize to their boss that they're committed to the job and that they need to continue earning an income. Armed with these and other expert tips that are found in the Shop Steward's Guide, you stewards can play an important role in preparing employees for conversations with their supervisors or with HR, and if need be, fighting back if a reasonable accommodation request is denied. So I'm going to turn it over now to Yona, who's going to talk a little bit about taking leave from work.
Thank you, Liz. In addition to the laws we've already talked about, which say that employers can't discriminate and must make reasonable accommodations, there are laws and contract provisions which can be used by pregnant women and women who experience childbirth to protect their jobs so they have a job to return to work after the birth of their child and after they have recovered and bonded. The federal law that provides leave is the Family Medical Leave Act, which many of you are probably familiar with. And in addition, some states and some cities have additional leave protection. There's some things it's important to understand, some of which you probably already know, but the Family Medical Leave Act is unpaid leave. It's also leave that is only available to workers who have already worked for 12 months, and it only provides for 12 weeks of leave over a rolling 12-month period. Some employers will be too small to be covered because a private employer must have at least 50 employees working within 75 miles of the worker that you're trying to represent in order for that worker to be entitled to be covered under the Family Medical Leave Act. And the worker has to have worked 1,250 hours, which would round out to averaging about 24 hours a week at least during the 12 months prior to taking the leave. But with those, next slide please, with those considerations, it is an important right that in terms of protecting the job, if somebody needs leave, either while they are pregnant or, of course, at the time of childbirth. So if a worker qualifies, this leave can be used to cover pregnancy-related illnesses such as serious morning sickness, or to cover regular prenatal doctor's appointments. And it also can be used to allow a worker to stay home and recover and bond after the birth of a child. However, there's some important concerns, issues to be concerned about when considering using FMLA leave or other leave. First and foremost, we've already noted that FMLA leave is not required that it be paid leave. While some state laws may provide some paid leave or some income replacement, the FMLA does not. So it's important to preserve, it's important to consider the person's economic circumstances and the fact that whether they are able to take unpaid leave or whether what they really want to do is try to reach some kind of accommodation and be able to continue to work. It's also important, because it's limited to 12 weeks in a calendar year, it is important that you preserve as much of that 12 weeks as possible for after the baby is born. So when a worker is forced to leave work or to take an extended leave during the pregnancy, that can mean that there will not be sufficient leave available afterwards for recovery from childbirth and any associated medical issues. It's also important to be aware, as I said, that this may not be economically feasible for workers who don't have the means to go without a paycheck. And if there is paid leave or paid maternity leave, the employer can require that the paid leave be used concurrently with the 12 weeks of FMLA leave. So in other words, you can't stack one on top of the other. Now, some union contracts provide for better maternity leave or child bonding leave. For example, there was just a news story today in the paper about a contract provision that was just negotiated by the ironworkers union to provide pregnant ironworkers with 6 months of paid leave before childbirth, in addition to 6 to 8 weeks of maternity leave after the birth of the child. And this was to try to encourage women who the company had invested in training them as ironworkers, which is a highly skilled trade, to stay in the trade. So this is a very favorable benefit. It compares very favorably with what's being offered to high-level, high-tech workers in Silicon Valley. Most of the workers that you're dealing with will not have such a strong benefit. And if you represent a worker who has had to use so much leave before childbirth that she finds herself having exhausted her FMLA leave before she is medically ready to return after childbirth, you might consider requesting additional leave as an accommodation under the ADA, as Liz spoke about. Now I'm going to turn this over to Carol Joyner, who's going to give you some more details about the better benefits, paid benefits in some states and localities. Thank you.
Thank you, Yona. We just thought it was really important to mention the fact that the national momentum for family leave has shifted over the years toward paid leave, and that absent a national law, many local coalitions, many of them including unions, have moved to pass paid family leave in California, New Jersey, Rhode Island, New York, and most recently in D.C. Combined, there are more than 23 million workers now in these states that have access to paid family leave. Most of this work builds on temporary disability insurance programs, which provide the medical care, or self-care as we call it, and then they've extended paid time for bonding or family care. So you can see in the New York case where there are, in the recent bill, when it finally comes into when it's fully implemented in 2018, 6.4 million workers will have access to paid family leave across New York State. They'll get 12 weeks. They already have a temporary disability program for medical care, so the time period they have, that's 6 to 8 weeks for pregnancy-related medical care, that their doctor can extend up to 26 weeks. On top of that, they'll also could get the 12. And in the pay that people receive, you'll see across the bottom bar that suggests the percentage of pay per for their salary, based on their salary. And of course, there's the first column, that's FMLA, note that it's unpaid, as Yona said. We're also looking at states that do not have TDI. So these states have TDI, they could build on that system. There are several states that do not have a TDI system, and that they're creating modern systems as they seek to pass paid family leave policies. And those states are Colorado, Washington, Connecticut, Massachusetts, Vermont, and others are gearing up to do the same. So there's this huge momentum around paid leave. And then there's also the Family Act, which is the federal bill for paid family leave that essentially is FMLA, uses FMLA rules, however, includes a social insurance fund for the payment. And so we're really excited that these laws are coming down the pike, either on a state level and hopefully one day on a federal level. But we can't underscore this point enough, that the time that you take, whether it's in these laws or what Yona talked about with FMLA, the time that you take before you have a baby can reduce the amount of time that you'll have available after the baby is born. And so counseling workers around how they apportion their time is really important. Although we also know that if you have to go out on leave, you just have to go out on leave. But there are some options developing in this country, and we're real excited about that. I'm going to move forward to the next slide, which I think is Liz. Thank you.
Thanks, Carol. That income replacement is really important for people to know about in the states where they offer it. So our final topic is going to be breastfeeding and lactation accommodations. And here I think it's important to provide a little bit of background about what this means and why it is important. So all relevant major medical organizations recommend that new mothers provide only breast milk for the first 6 months of their baby's lives, and then continue breastfeeding in combination with feeding other foods until the baby's a year old. And that recommendation isn't just for the health of the baby, but it's also for the health of the mother. Now, whether to breastfeed, of course, is a personal choice, and it may not be medically available to everyone, but for those mothers who are breastfeeding, one of the biggest hurdles that they face is unsupportive work conditions and a lack of break time and space to pump breast milk. Women who are away from their babies during the workday have to express or use a pump to express breast milk regularly throughout the day. And that typically can be every 2 to 3 hours for individual sessions that can last between 15 and 30 minutes, depending on the individual. And if these people don't take time to pump, they're risking painful breast engorgement, infection, even decrease in their milk supply that can interfere with their ability to breastfeed in general. So this means that accommodations may be needed for breastfeeding in the same way that they may be needed for pregnancy. At a bare minimum, workers who are breastfeeding need breaks from work and a private clean space to pump breast milk. And keep in mind that breast milk is food, so this space should not be a bathroom stall. If there's an electrical outlet to power the breast pump, running water, a refrigerator available, then that's even better. In some cases, because of the nature of the job or a health condition that the mother or the baby has, even additional accommodations may be needed. So with that background, I want to tell you a little bit about the woman that you see pictured here, Stephanie Hicks. She's pictured here with her kids. Stephanie was a police officer in Tuscaloosa, Alabama, and she was also a breastfeeding mother at the time. Stephanie's doctor recommended that she continue breastfeeding her baby after her FMLA leave expired and she went back to work. So as is common, the doctor said that Stephanie needed regular breaks and she needed clean, private space to pump breast milk. But in Stephanie's case, there was an additional accommodation needed. All of the officers who went out on patrol, who went out on the beat, wore a bulletproof vest for protection. And Stephanie's doctor advised that she couldn't wear that vest because it had to be worn so tightly that it would impact her milk supply and could cause infection. And it had to be worn tightly, of course, to protect the vital organs. The doctor recommended that Stephanie be given an alternate assignment. So when Stephanie took her doctor's note to her supervisor at the police force, they refused to place her on desk duty, even though other officers who had work restrictions were regularly given that accommodation. Her employer even suggested that she go out on the beat without the bulletproof vest, something that nobody did because it was be extremely dangerous to do so. So essentially, when you think about it, Stephanie's employer forced her to choose between her job and breastfeeding her baby. And this is an impossible choice. Stephanie lost her job with the police force so she could continue providing breast milk for her baby. So the question that I want to look at is whether this was legal. Now, a jury actually ruled in favor of Stephanie and against her employer, finding that the employer violated the law when it denied Stephanie the accommodation she needed. There are 3 sources of law that provide rights to breastfeeding workers. The first is the Break Time for Nursing Mothers Law. It's a provision of the Affordable Care Act that amended the Fair Labor Standards Act to require that employers provide unpaid break time for employees to express breast milk as needed throughout the workday. Under this law, the employer must also provide a place that is not a bathroom, that is shielded from view and free from intrusion by coworkers and the public, where the employee can go to pump breast milk. Now, this law applies only to employees who are covered by the FLSA, or the Fair Labor Standards Act, overtime protection, so people who are entitled to overtime under federal law. It doesn't apply to everyone then, but it's still an important legal protection for nursing mothers. The second law that is relevant here is the one that we talked about earlier when we were discussing pregnancy, the Pregnancy Discrimination Act, which you'll recall requires accommodations for pregnancy when accommodations are given to non-pregnant employees for other reasons. This same law also requires that accommodations be provided for lactation when they're given to other employees. So take, for example, a smoker is allowed to, or smokers are allowed to take regular breaks throughout the day, then nursing moms should be allowed the same thing. Finally, there's a significant number of states that have laws that require employers to accommodate breastfeeding workers. And these state laws may provide protections in situations where the break time for nursing mothers law under the FLSA or the Pregnancy Discrimination Act don't apply. So shop stewards can make sure that employers are not denying members these important legal rights, and you can also play a key role in preparing a worker during her pregnancy to think about what she may need when she returns to work. It's always best not to wait until the first day back to come up with a plan for pumping during the workday. So there's more on that and the laws that we just discussed in the Shop Stewards Guide that we've been mentioning throughout the program. With that, I think that I will turn it back over to Carol.
Hey, thank you, Liz. That was great. So we're running to the end, but we wanted to just finish with recognizing the Shop Steward's Guide. You see it there on the screen. It's the Shop Steward's Guide to Counseling and Representing Pregnant Workers. It's available on both the Work Life Law website and the Labor Project website, working-families.org. There's so much to cover, and we can only do the highlights, but if you look at the manual, you'll see much more detail and many other references and tools that you'll be able to use. There are also some wonderful, as I said earlier, tips for shop stewards that we're hoping that all of you will be using. There are also additional resources about the ins and outs of the state and federal laws and relevant CBA provisions. And also on the Labor Project website, we have updated our contract database that provides examples of CBA language for pregnancy accommodation We're going to add the iron workers as soon as they send us that contract language. So thank you for that, Yona. And we also have other related issues and work-family policies in that contract database as well. I'm going to turn it over to Tiffany, who will talk about very briefly how it could have been different for her if she had had a union armed with a guide like the Shop Steward's Guide to Counseling and Representing Pregnant Workers. Tiffany, do you want to talk about that and end us and wind us up with some suggestions that people might want to walk away with?
Sure. While working at Walmart, if I was a union member and had access to this toolkit, I would have been aware of my rights as a pregnant worker, as well as able to educate other women of their rights during their pregnancy and working on the job. Here are 3 ways that shop stewards may utilize this toolkit when confronted with a pregnant worker. 1, reach out to the person and see if they're open to discussing their plan. 2, ask if they know their rights regarding continuing to work, pregnancy accommodations, breastfeeding accommodations, laws and contract both. 3, ask how the union can best support them throughout the pregnancy, throughout their pregnancy leave and return to work period.
Thank you, Tiffany. So that wraps it up for us. I'm going to turn this back over to Liz or Anna for questions and comments. Thank you, everybody.
Wonderful. So we've already received several questions. If anybody has additional questions, you can type them directly into the questions box that you'll see in the panel on the right side of your screen. Or alternatively, you can email them to questions@worklifelaw.org, questions@worklifelaw.org. So let's jump in. The first question is for Carol, and this participant wants to know, what is TDI?
So TDI stands for the Temporary Disability Insurance, and there are 5 states that have TDI and have had TDI. It's an insurance policy that in most cases employers and employees, depending on the state, pays into, and it guarantees medical coverage for you when you can't work. In the 1970s, many of these, almost all 5 states, actually, all 5 states added on the ability to use TDI for pregnancy. We don't like the idea that it's disability for pregnancy, because pregnancy is not a disabled state, but it does afford time off for people to recover for that period of time. Usually 6 to 8 weeks is what the doctor will allow, and it's based on the doctor's recommendation for pregnancy. And so the states you see there, not including DC, but including Hawaii, so New York, Rhode Island, California, New Jersey, and Hawaii, all are TDI states. And so because that infrastructure is already set up, those have been the states that have been more able to create paid family leave systems because they build it on top of the TDI system. If that's not clear, just let me know and I can go further. Thank you.
Thanks, Carol. The next question I think we'll direct to Yona. What should a shop steward or union rep do if someone comes to them for advice because they believe they've been discriminated against?
Thank you for that, because that's a really good question. I have some suggestions. I'm sure these are not exhaustive, but I think the first thing to do is kind of talk to the worker who's coming to you and get some more details about why they feel that way and what's been happening and what evidence that they have. So, it depends on the situation. Maybe there have been some comments made, or maybe the person has overheard something, or someone has told them something. So, you would approach that kind of issue the same way you would any grievance, where if the grievant comes to you with the complaint, you're going to try to figure out exactly what their concerns and complaints are, and then you're going to do your research, just like you would in any case, to determine whether there is a basis for taking it further. So one thing you would do would be follow up if there are any witnesses, or if things have been reported to that person that the person is then telling you. And then I think you you as the steward do have access to information that, just on the floor worker might not have. So for example, you have some access to information about how non-pregnant workers have had have been treated in similar situations. So you can use all the normal resources you would use in investigating a grievance to look into these kinds of claims, and then to make a determination whether there is something that can be done, and to start to come up with a plan of how to pursue that. So.
Thanks, Yona. So we have 3 breastfeeding questions. I'll try and answer these all together. The first is, do breaks for nursing mothers have to be paid? Now, the answer to that is that under the Break Time for Nursing Mothers Law that amended the Fair Labor Standards Act, breaks do not have to be paid. However, if the nursing employee uses break time that is otherwise paid, their normal break time that everybody receives pay for, then they have to continue to be paid for that time, just like all other workers. Also, keep in mind that generally we know under the Fair Labor Standards Act, and if an employee isn't relieved of all duty during their break, then that time counts as hours worked. So if they're still expected to answer the phone or do whatever while they are pumping breast milk, then that doesn't all of a sudden become unpaid time because they're pumping breast milk. The next question concerning breastfeeding. I heard that the FLSA break time law does not apply to work sites with fewer than 50 employees. Is that true? So the Break Time for Nursing Mothers Law applies to employers of all sizes who are covered by the FLSA, which we know most employers. However, and this is a common misconception actually, so I'm really glad that this was raised, there is an exemption or a defense if providing the break time and space would cause an undue hardship for the employer when the employer has 50 or fewer employees. So employers of more than 50 employees have to provide the break time and space no matter what. If there are fewer than 50 employees, they have a defense that they can raise where they can say there was an undue hardship or a significant difficulty or expense, and so we didn't have to provide the break time and space. But it's important, especially in the unionized context where you can counsel people, to keep in mind that you should be creative in coming up with solutions. So, it may seem at first blush very difficult to provide space at an outside workplace like a construction site, but keep in mind that you could provide an inexpensive pop-up tent that would provide privacy. So important to stay creative and to really push back against any employer that says that there would be an undue hardship. The other thing I noticed about this question is it asks whether the break time law applies to work sites with fewer than 50 employees. It doesn't matter how many people are at the work site for purposes of this defense or exemption. What really matters is how many employees the employer employs in total. So there could be 5 people at the work site, but the employer has 1,000 employees, and that's sufficient. They're covered by the law no matter what. And the third question that we have here is, when pumping at work, you need to pump more often than you have paid breaks. What accommodation does the employer have to provide for these additional pumping sessions? And for that, we will look back to the Break Time for Nursing Mothers Law. The employee if the employee needs more time than the paid breaks, then the employer is required, if the employee is covered by that law, to provide breaks as needed throughout the workday. And then if the person is exempt from overtime and therefore not covered by that law, we would look at the Pregnancy Discrimination Act and try and figure out, and again, people in unionized workplaces are in a great position to do this, figure out what accommodations are other people receiving, and the breastfeeding employee would be entitled to accommodations as well. Okay. The next question that we have is for Yona, do pregnant women applying for a job or a promotion have to disclose that they're pregnant? So I think the question is whether they have an obligation to disclose that.
Okay. And I think my answer to that question would be no, that you don't have to disclose it. I think if you are going to be asking for some type or need some type of accommodation, then obviously you're going to have to disclose it in order to request the accommodation. But if you are, it's certainly, I don't think there is any legal obligation to tell an employer, hey, I'm 5 weeks pregnant. I'm applying for this job and I'm 5 weeks pregnant. No, there is no obligation. It's up to you when you inform the employer. The only requirements would be, as I said, if you need an accommodation, obviously you're going to have to notify the employer in connection with requesting that accommodation. And then secondly, in terms of your Family Medical Leave Act, to the extent that it's predictable that you're going to need to take leave, you need to make that request 30 days in advance of when you expect you need the leave.
Great, thanks, Yona. I think the next question you may be able to address is as well. It's how is prenatal care defined in already existing laws or in typical CBA language? And the reason that the person's asking this question is they want to make sure that birthing services like doulas and midwives and potentially other prenatal services besides seeing an MD are covered because that's important for a lot of marginalized communities that may not access Western medical models. So I think we can think about that under the sort of general, there's obviously no one size fits all, but under collective bargaining agreements in general, as well as under the FMLA.
Yeah, I'm thinking, it's not a question I've actually thought of before, so I'm kind of doing this off the top of my head, so I make that I might think about it more and come up with a different answer later, but I think my initial reaction is twofold. First of all, I think that the FMLA is pretty broad in terms of the definition of medical providers. So for example, there's a dispute as to whether chiropractors or, counselors, that kind of social workers, those kinds of, I think it's broad enough to include that. So I think certainly it would include the type of person that you're talking about in the question. And similarly, I think most collective bargaining agreements are fairly broad in scope in terms of defining medical practitioners as well. So I think it would be covered.
Yeah, I would agree. Yeah, I would agree with that. So my understanding is that midwives are typically nurses, so that they would be medical care providers covered by the FMLA, and going to your midwife appointment would likely be covered. I don't know if there's any case law on that either. Doulas are. That's a question that I'm not sure about under the FMLA. It would probably be a close case. But if somebody has a specific situation in mind, please feel free to follow up with me after the webinar, and I'd be happy to talk it through, think it through a little bit more. Okay, the next question. Are there any protections in place for unemployed women that are pregnant? For instance, if an interviewer says something along the lines of, I'd love to hire you, but you're pregnant and I need someone who's going to be available right away. I can take that question. So the answer is that it is patently illegal not to hire somebody because of their pregnancy. And that's illegal pregnancy discrimination under the Pregnancy Discrimination Act and under the laws of various states. Of course, we actually have a related question here about whether Yona already answered that. That's related to the question of whether a pregnant woman is required to disclose that she's pregnant. If, sometimes it's obvious, but if it's not obvious yet, then no, she does not have to disclose that. And the employer cannot deny her opportunities because of pregnancy. Okay. The next question that we have is, what advice should we give pregnant women who want to know when to tell management that they're pregnant? So the important thing to know here is that there aren't any strict deadlines for when to announce a pregnancy, when to tell your employer that you're pregnant. But there may be reasons why that you would want to tell your employer that you're pregnant. So you should definitely not do it before you're comfortable doing it, disclosing that information. But if you need an accommodation, you may have to tell the employer that you're pregnant to be covered by the Pregnancy Discrimination Act or a state level pregnancy accommodation law. Also, if you're going to need time off under the Family and Medical Leave Act, as Yona mentioned during her presentation, if the need for the leave is foreseeable, you have to give 30 days advanced notice. There's no hard deadline, but there may be reasons why you would want to tell. And of course, in the Shop Steward's Guide, we have information that you can take a look at that sort of provides tips and guidance for how pregnant women should approach that conversation with HR or with their supervisors. So we encourage you to check that out. Carol, were you going to say something?
Oh.
Yeah, I actually wanted to add something to that. The guide offers an opportunity for there to, of course, be representation and counsel on the job, but for also there to be some culture change. And so if many unions are using the guide and workers are aware that the guide is being used in, delegate and shop steward training, on the shop floor, or if at, small meetings of members, there's some mention about this, a woman who is pregnant, who hasn't even thought to talk to their shop steward or anyone from the union about their pregnancy, may open up about it. And so we're hoping that unions will take the guide and think about it as a bigger conversation that needs to happen in the workplace about how, one, for pregnant workers, how they can talk about this because they have protection, and from the union's point of view, how they now have a guide to support workers. So thinking it more about in that way, as opposed to waiting until someone is pregnant and then hoping that they know that there's someone to talk to about it, would be a much better thing.
Can I jump in too? This is slightly different from what Carol was saying, but I just wanted to respond based on some experiences of cases I was involved in previously, that if the pregnancy, I do think it's personal how soon somebody wants to announce their pregnancy, but if it's out, or if a lot of friends know, or you are on Facebook with a lot of work people, and there's something on Facebook that would, so if in fact the employer really knows, then, or is likely to know, then I would suggest formally telling them so that they can't say, oh, we didn't, in case there is some type of discrimination, there can't be sort of like, oh, we had no idea she was pregnant, when in fact they really did know.
That's a really excellent point, Yona. And I'll add to that people should also take into account that supervisors and coworkers often would like to know, relatively early on so that they can plan accordingly. And so somebody who discloses that information, again, once they feel comfortable, but not at the last minute, can help to make the transition smoother, which will benefit them ultimately. So the next question that we have, do you know if the FMLA runs concurrently with other leaves such as the pregnancy disability leave and the California Family Rights Act? So that's a California specific question, and the answer is that yes, the FMLA does run concurrently with leave provided under those other two laws. The next question, as a county legislator, I introduced a bill to identify locations for county workers to provide lactation rooms. We've just opened 2 rooms. They're accessible to the public too. Can you forward a copy of the CBA agreements for the union? They're currently negotiating a new contract. FYI, the legislation was a result of a conversation with Deirdre Schiffling. So I think that's something that Carol can address, maybe tell folks a little bit about the database that your organization operates.
So we've just updated a long-standing database for the Labor Project for Working Families, and it has about 1,100 pieces of collective bargaining language. Some of it is pregnancy accommodation language. And so I would be interested in knowing a little bit more about the union that the person who asked the question is with, and to maybe follow up offline about, you know, getting them more information, and also getting the information that they have about the pregnancy accommodation or lactation centers or rooms that they set up. Yeah.
Okay, so sounds
Liz,
like
I was just
please go ahead.
Liz, I was just going to add that for yet another plug to the Steward's Manual, that there's a chart at the end that has a lot of sample contract language.
Wonderful. Okay, the next question, and Yona or Carol, feel free to jump in. Are you aware of any unions who have tried to get paid parental leave into their union contract or through an MOU post-contract? I think Minnesota did this, but I'm not sure if it's been successful. I've also heard of Washington Teachers Union creating a parental leave bank that union members contribute to and receive up to 30 days in paid leave. I want to find out more about how I can get momentum and support through the union to implement paid parental leave in a state that does not have TDI. Thank you for this wonderfully informative webinar.
So there are several unions that have negotiated paid family leave. One off the top of my head is the Professional Staff Congress, which is an AFT local in New York City. They were able to negotiate some paid leave time, I think 9 weeks of paid leave. But what we've seen in looking at the pregnancy accommodation language, the majority of the language is it gives workers the ability to take time that they already have negotiated, like paid sick days, paid sick leave, or vacation pay, or some other type of pay, and use that for their leave. When they live in a state with paid leave, they can usually extend their leave with that additional time in the contract. And for folks that don't live in a state that currently have paid leave, or I think there was a question about how can you, a part of this question was about TDI or states that don't have a TDI system. I mentioned several states that are working right now on the technical and programmatic planning to develop a paid family leave system that has no TDI to build on. I mean, DC, it's not a state, clearly, but it is an example of one of the first places that have passed paid family leave, and they are now having to create an implementation process, a whole new department or a section of a department, they haven't decided yet, to build out for paid family leave. So it's happening, and we have models. In fact, the Department of Labor under the Obama administration had paid family leave state grants that states were able to get access to so that they can plan ahead, and build out the technical and the programmatic systems. in order to develop a program. So I don't know what is going to happen. They've had those grants for the last 5 years. I don't know what will happen going forward. But if the person who asked the question would like to get in touch with me, my email is there, and we can talk a little bit about what's possible in their state.
And I was just going to jump in because I heard something, maybe I misheard the question, but I heard something that suggested to me you were also asking about sort of cooperative or leave sharing arrangements. So, and I have seen in some contracts where, people who have a lot of saved sick leave that they don't think they're going to need have donated it to be shared with somebody who needs paid sick leave to cover some type of paternity or maternity leave. And also, if you're asking about, I do think that there is starting to be more of a recognition that sort of there are two different kinds of aspects of leave that people might need. One is really directly related to medical issues that might come up either during a pregnancy or after, medical issues that follow on delivery. And then secondly, the need for parents, both mothers and fathers, to spend time with their newborn bonding. And so I think you're starting to see in more contracts that there is some provision for during the first, over and above, of course, that is also something that is recognized under the Family Medical Leave Act, but also more provisions in collective bargaining agreements to give that type of leave, parental leave.
Thanks, Yona. I want to let everybody know that we are at the 60-minute mark right now, so if you have to hop off, then we understand. However, we're going to stay on and answer the rest of the questions, and the webinar is being recorded, and you'll receive it by email afterwards. So if you do have to hop off, you'll still have an opportunity to listen to the rest of the Q&A session. So the next question is, if an accommodation will cause economic impact on the employer, what's the extent of the pregnant employee's rights? So this person says, for example, she or he represents housekeepers. A reduction in workload, i.e. rooms per day, is a financial impact on the company because they need to have more staff on to finish the rooms each day. How far do the laws that you've discussed go with regard to what's required when there's going to be some sort of financial impact in the interest of accommodation? Now, the fact that there's a financial impact does not mean that an accommodation should not be provided. Oftentimes there is a financial impact when an accommodation is required. Now, with pregnancy, we always want to keep in mind when we're advocating for people that the accommodations are temporary, and research shows that typically they're low cost or cost free. However, if there's a financial impact, that doesn't necessarily mean that somebody's not entitled to an accommodation. So under the Pregnancy Discrimination Act, there was a recent Supreme Court case that said that the employer's justification for not providing accommodations couldn't just be cost or convenience. Now, that's not to say that cost can't be taken into account at all. Of course, every business decision takes cost into account, but simply the fact that it will be more expensive is not a reason not to provide accommodations under the Pregnancy Discrimination Act when those accommodations are being provided to other employees. That's probably costing something as well. Under the Americans with Disabilities Act, having some economic impact is fine. But there is a defense that employers can raise called the undue hardship defense, and that defense basically says that the accommodation, providing an accommodation, would impose an excessive difficulty or expense. And so what it actually means to have an undue expense will depend on the size of the employer, the resources of the employer, sort of the situation overall. So it's not irrelevant to the question of whether somebody's entitled to an accommodation, but the fact that there's an economic impact is not just on its own a defense that an employer can raise as an excuse to not providing an accommodation. Okay. Yona, did you have anything to add to that?
No, I think you covered it.
Okay, great. So the next question, regarding pregnant transgender workers that are not women, does legal language tend to use gendered language such as women and she, her pronouns? This participant says, I know of transgender men who are pregnant and wondering if they would be covered by the laws. That's a great question. And so under the Pregnancy Discrimination Act, the fact that the person is transgender and doesn't identify as a woman, he, she, is irrelevant because the law protects people from discrimination on the basis of pregnancy, childbirth, and related medical conditions. That means so long as the person is pregnant or has had a child or has a related medical condition, that person is covered by the law. If there's a state law at issue, of course, you always want to consider whether there's state law protections. You'd have to go and look at the exact language in that particular state. And then under the Americans with Disabilities Act, it's not something that's based on gender at all. It turns on whether the person has a disability. And so transgender worker would be covered if they, just like every other worker, had a disability under that law. The next question that we have, are you aware of any paid maternity or paternity leave policies where employees are not full-time employees in the traditional sense? Yona, do you want to handle that?
Sure. I'm trying to think. I think that when you talk, I mean, I guess we have varying schedules in terms of full-time employment. So I think I think I have seen policies that don't make the distinction. I think some policies do make the distinction in terms of, just as any like holiday pay or something is maybe reduced if you're working a part-time schedule, I think. So I'm just trying to, I don't know that I have any good examples to give you one way or the other on that.
I don't have good examples either, but in most cases it's not based upon whether you're full or part-time, but based upon whether or not you accumulate a certain number of hours. So a part-time person in most cases would be eligible, but they would have probably to work for like many more weeks or days, whatever, in order to get the a significant amount of time.
Right, and under the Family Medical Leave Act, as I had mentioned originally, you have to have worked 1,250 hours, which comes, when I divided that by 52, it averages 24 hours a week, which is less than full time, but fairly substantial number of hours over the course of a year.
So the next question, is there any chance the Pregnant Workers Fairness Act will be introduced in this Congress? I don't know the answer to that. Don't know if any of the other panelists do. Obviously, we have an uphill battle given the current composition of our government. It's been introduced in the past, and the Pregnant Workers Fairness Act, by the way, is a law that would provide accommodations to pregnant employees without having to show that other people in their workplaces received accommodations, without having to show that they have a disability under the Americans with Disabilities Act. It would just give them a straightforward, clear right to accommodations. So it's a very important law, and as we mentioned earlier, we have these types of laws in many states, but I'm not sure if it's expected to be introduced in this Congress. One interesting thing to note is that in the states where these laws have been passing over the last few years, they have been passing with bipartisan support oftentimes. So there does seem to be support from both sides of the aisle for these types of protections, although, as we all no. Any kind of regulation of business is not is not something that the current administration looks favorably upon. Does anybody have anything to add to that? Any knowledge?
I was just going to say that I think the Pregnant Workers Fairness Act Coalition is looking forward to an introduction somewhere around Mother's Day. So a reintroduction somewhere around Mother's Day. It's probably, as Liz said, not going to go too far. In the past, it's probably the only one of the working family bills that actually had 2 or 3 Republicans as co-sponsors and supportive of the bill. But we're thinking that in this current environment, we may lose those 3. But it is going to be introduced. The question is, how far will it get? Will we even get a hearing?
And I was just going to add, I agree. That's what I understand as well. But I do think that maybe the thought is that it's a more fruitful place right now for this kind of activity is in either state or by locality. And I think there's going to be efforts at the state and local level in some places.
That's right. I think that's right, Yona. And the only other thing I would add to this is that we are constantly on the lookout for, faux bills that look like they would help pregnant workers, or bills that are really great for leave, but really are not. In the end, they essentially allow the leaders in Congress to check the box to say we're supporting women's issues. But at the end of the day, they really don't go far enough. So keeping our eye on the prize, knowing that the Pregnant Workers Fairness Act, the Family Act, the Healthy Families Act, these forms of bills are pretty much tested and will provide the largest protection for working families, is really important. Also, it's important to keep our eye out for anything that looks like it might protect pregnant workers, but at the end of the day is like a tax cut or something like that.
Really excellent points, Carol and Yona. And we are out of questions, so unless any of the panelists have anything to add, we will wrap it up. And thank you very much to all of the participants and the panelists for joining us today.
Thank you, Liz. This was great. Thank you so much.
Thank you, everyone.